My name is Jonathan Cohen. I'm a partner at NextLaw Professional Corporation. I'm here with Dan Joffe, who is a senior lawyer at NextLaw. There's a series of common questions we get about being charged with driving while suspended that we thought would be useful to explain to you in this video. First question is, I just got pulled over by the police and was charged with driving while under suspension, which falls under Section 53(1) of the Highway Traffic Act. Dan, what just happened to me?
Hi, John. What just happened is that you've been charged with a charge under the Highway Traffic Act. And driving while under suspension is not a minor charge under the Highway Traffic Act. In fact, it's one of the most serious charges under the Highway Traffic Act. In fact, it's considered a quasi-criminal charge given the potential serious penalties, which include a mandatory 6-month driving suspension, which means on a conviction, you can't drive for 6 months. So you can't do what you need to do to feed yourself, to feed your family. And if you're a repeat offender, your penalties may include jail time up to 6 months as well. And the reality is that driving while under suspension is a very serious charge.
So now explain why these penalties are so severe.
It's important to understand the difference between a regular traffic ticket and a serious traffic violation that's effectively a quasi-criminal charge with serious penalties. And it all has to do with public safety. A car weighs 4,000 pounds, and the law treats it like a weapon on wheels. And if not operated properly, that weapon on wheels, can kill someone. You can put someone in a wheelchair. You can cause significant property damage. So to minimize the risk to the public, the law requires that you're properly licensed to handle a car. In other words, that you're properly prepared to handle a 4,000-pound weapon, and being properly licensed means understanding how to safely operate it, means to take proper care of the vehicle to ensure it's safe to drive, means understanding what you can do, what you can't do on the road, et cetera, et cetera. And the logic goes, when you're charged with driving while under suspension, that effectively means you're not properly licensed to handle that weapon. And the lawmakers prescribe penalties that are consistent with someone who's operating a weapon, and those penalties include this mandatory 6-month driving suspension, and in certain circumstances even includes jail time. These strong penalties have really a dual purpose. First, they're aimed to deter you from doing this, and they deter you because they say you can't drive for 6 months unless you're properly licensed. And secondly, these penalties are aimed to send a message to the public that if anyone operates this 4,000-pound weapon while not properly licensed, that the law is going to punish them in a very harsh manner.
Another common question we get all the time is, okay, I just got charged with driving while under suspension, and I have a lot of fines that I can't afford to pay now. Is there any way to get my license back now so I can drive before paying all these fines?
It's a good question, and we hear that all the time. And the short answer is, and the good news is, yes. You can enter into a payment plan with the court. Once you enter into that payment plan, you may be able to get your license back. However, the details are important. The details about your fine. I mean, how much is owed? How old are the fines? Are the fines with the court, or are they held with a collection agency? Which court or courts are your fines in? All these factors can have an impact on whether you can get on a payment plan and get your driver's license back. There's a lot of moving parts here. If you want to learn more about how to get your driver's license back before your charges have been litigated, I suggest that you give us a call and we can discuss the details of your case.